we'll keep track of that, right? And at least we get our introductions out of the way. And if somebody joins, we'll make sure we identify who those folks are. So right now we have only people from Park Plaza Co-op. So Carlton, Natividad, and whoever's with Natividad. So this is, these folks are from Park Plaza Cooperative in Fridley, Karen. Okay. So as background, I volunteered to be moderator of this because I received lots of questions about the eviction process. We were just talking about this morning in a session we had. And a result of the COVID crisis, most of the communities we work with are struggling with how to address lot rent delinquencies. So I've asked Karen to focus on, specifically on lot rent in relation to the work she does. Karen began her career as an English as a second language teacher, and for 11 years lived in Rome, Italy from 1990 till 2001. So does that mean, Karen, that you can speak Italian?
Sì, parlo italiano.
All right. So when she returned to the US and to Minnesota, she decided to go to law school. She's a 2005 graduate of William Mitchell College in St. Paul, and she began practicing in 2006. And for the first 4 years, she worked at a small firm. Since 2010, she's been a solo practitioner, and she focuses on business and employment law, as well as housing. She works with small businesses such as landlords and other businesses, helping them protect their business and their interests, whether it's through eviction actions as with landlord clients or through contract drafting and review with other clients. She also teaches at the University of Minnesota Law School and has been teaching legal writing there since 2011. Karen, as a point of reference, NCF works with 9 resident-owned communities. We call them ROCs. So if you ever hear that term, it stands for resident-owned communities. So there's 9 in Minnesota and 3 in Wisconsin. You have one of those ROCs on the call right now. And as other people, or if the other people join, I'll make sure I let you know. So sometime during your presentation, there's a couple of things that I hadn't talked with you about before that I want to make sure you address. And one is, and maybe this is part of your presentation anyway, but what restrictions are there in terms of you as an attorney, where you can work, who you can represent, either, you know, because you're licensed in the state of Minnesota, for example, or either by state or by county. So I think that might help people understand what your limitations are, not yours specifically, but all attorneys that they may work with. Mm-hmm. And the second is that there's confusion about moratoriums. Mm-hmm. You know, there's a state moratorium, there's a federal moratorium. So if you could talk about what's currently in effect, who that moratorium applies to, I think that'll help people a lot. And I'm going to monitor the chat box so that we'll try to address any questions that come up at the very end. So I'll keep track of that, and I'll let you know what that looks like. There's nobody new on the call. It looks like Natividad and whoever you're with just got on video as opposed to just phone. So I think I'll just turn it over to you, Karen.
Okay. I guess I'll start with the first question that you had, Tom, and just kind of give you an overview of to everyone of who I can work with, or who any attorney can work with when they're licensed in one state, like I am. I'm licensed just in Minnesota. So that means that I can carry out the practice of law within the state of Minnesota. So I can appear in Minnesota court in any county. I'm not limited to just Hennepin County, where I live and where I work. So I can appear in any state court. Right, currently I'm not certified to appear in federal court, but I could. I have been in the past and could reactivate my certification in Minnesota. So a license to practice law in the states is state specific. I could advise clients who happen to be in Wisconsin and advise them on Wisconsin law. I probably wouldn't because I'm not familiar with Wisconsin law, but that's not outside of what an attorney can do. I can't go to Wisconsin and practice law, so I can't set up an office in Wisconsin, even if I were advising clients in Minnesota, because I would be practicing law in Wisconsin. And likewise, without permission from the Wisconsin courts, I can't appear in court in Wisconsin. And generally, just because attorneys by nature, by training, we tend to be cautious and prudent, most attorneys will just advise clients in the states, or clients about the law in the state in which they are licensed. So that's how it works with attorneys and our licensure, and what we can do. And I think the question about the moratorium, once we get into some of the options, we can talk about that, because it'll kind of fit nicely into some of the slides and the information that I prepared.
Excuse me, Karen, I see somebody from a 507 number just joined us. And who's that?
Danny from Pommel Creek.
Hey, Danny, welcome. So Pommel Creek is in La Crosse, Wisconsin, Karen.
Okay.
And I have a 608 number. Who might that be?
That's Peggy from Pommel Creek.
Okay, so we have Danny and Peggy from Pommel Creek. Okay, so Karen just started her presentation, you guys.
Oh, sorry.
That's right. We just did introductions.
Oh, and Peggy, okay. Well, for both Danny and Peggy, then I'll just let you know that when I'm talking about the laws, regarding whether it's repossession or for eviction, I'm referring and referencing only Minnesota law, since I'm practiced here. So the Wisconsin law, of course, as you probably know, could be different. So just keep that in mind.
Okay, we have one more person on a galaxy. Who would that be?
Tom, that's also Danny from Pommel Creek.
Is it?
Yeah.
Okay. I got it. All right, that's it. I'm going to hold off now, Karen. Go ahead.
Okay. All right, so let's first go through kind of what we'll go over. So my presentation focuses on, first, what are the options for going to court in the landlord-tenant context? And that will be both in the housing context and also in the context of collection. So those are the two areas that we'll focus on: housing court, and then if you have to go for collecting any amount due. I'll also talk about enforcing a judgment and collecting what defendant, resident might owe you. And then a lot of my slides also have some tips and suggestions about what to do in the context of collections and managing tenants and dealing with them with court. And then I'll leave some time at the end with Q&As, but I think also because there's so few of us, that it might make more sense if you have a question, especially if something that I say isn't clear, if you're not, quite following what I'm saying, just let me know, either with a question that Emily, you can flag it. If, we have some video, I know not everyone has video up, but raising hands works really well as also. So however you want to do it, we can take questions during my presentation as well. So with that, for the presentation, I thought it would be helpful to give us an example that we'll be talking about within this context of going to court. So, and I'm going to be talking about a lot of different options. If you're in court, if this happens, what you can do. So, and it's all can be rather complex. And I find that when we're talking about kind of more complex issues, it can help to have an example to refer to. So I'm going to refer to this imaginary resident tenant in your park named Donnie. And Donnie has a house that he wants to rent a lot for in your park. And different things happen with Donnie that we'll be talking about. And you all are the managers at a park that is named Cherry Grove Park. And you're the park manager, and you've rented a lot in the park to Donnie. And you've signed a lease agreement with him under which he's responsible for the utilities. And we'll discuss different situations involving Donnie and the park and the lease that you signed with him. So that's kind of our scenario for what we'll be talking about today. So first thing about Donnie, he's turned out to be not the best tenant. So he's defaulted on the rent that is due. He owes about 2 months of rent plus utilities for a total of about $1,000. He's also creating disturbances in the park, and he plays loud music at all hours of the night. You've gotten a lot of complaints about Donnie from other residents, and you want him out of the park. So we're going to talk about what you can do to achieve that objective. So with that, this is a flow chart that kind of summarizes the options that a landlord has against a tenant. For a tenant that you want to remove, and also a tenant that owes you money. And we'll talk about everything that is on this, this flow chart. The first one we'll talk about over here is housing court. So housing court is a specialized court in a more populous county like Hennepin County, is a separate court from regular court, what we call district court. And in counties that are smaller in terms of population, the housing court is often with regular court. So there will be just a few judges that listen to all cases. However, Hennepin County, Ramsey County, Anoka County, some of the counties here in the Twin Cities have a separate specialized housing court. And when you go to housing court, first thing to keep in mind that housing court has a really limited focus of the type of claims that can be brought. And there's really just there are two types of claims that can be brought in housing court. The first is an eviction action, which we also call an unlawful detainer. And there's also another type of claim called a rent escrow. So the first, an eviction action, that's the claim that a landlord brings when the landlord wants to evict a tenant. And the eviction claim, or the eviction action, we can call it, is generally based on non-payment of rent. But it can also be for a breach of a lease, a provision in the lease, or even a violation of a Minnesota statute. There's a whole chapter of statutes in the Minnesota law that deal with landlord-tenant. So there's different grounds for which you can bring an eviction action. But regardless of the reason, you as the landlord, you're claiming that the tenant has breached the lease by failing to pay or by doing something else, and is no longer entitled to remain in possession of the property. We also call an eviction action an unlawful detainer, and you might hear people talking about a UD. I filed a UD against a tenant. And we call the eviction action also an unlawful detainer because as the landlord, you're claiming that the tenant is unlawfully detaining or retaining possession of the property. And, but they're the same thing. You can call them either one, people use the same terms. You probably know that to bring unlawful detainer action or eviction action, you have to be represented by an attorney if your business is a corporation, an LLC, a legal entity. An individual doesn't have to be represented by an attorney, and very often in housing court, the tenant, the defendant, isn't represented by an attorney. We call that being pro se, that the tenant is representing themselves. A couple of terms also, the person who brings the claim or files the eviction action is called the plaintiff. So the landlord is the plaintiff, and then the defendant is, of course, the tenant. So if your park is organized, which I assume it is, as a corporation, then your attorney, of course, is filing the eviction action or the UD on your behalf. So once the complaint is filed, Minnesota law requires that within 14 days, a hearing has to be heard or has to be filed. No, a hearing has to be scheduled. Let me try that again. So from when a complaint is filed, the hearing has to be scheduled within 14 days. And at that initial hearing, there is simply one issue that the judge will decide, and who has the right to possession of the property. And that's it. So a judge in housing court can't rule on any other issues that are outside of this narrow issue of who is entitled to possession of the property, the landlord or the tenant. So at this first initial hearing, the defendant, will deny or admit the allegations in the complaint. If that's non-payment of rent, usually the tenant, the defendant, admits that, yeah, I haven't paid the rent. There's usually nothing in dispute. And in housing court, about 98, probably 99% of the claims that are filed are for non-payment of rent. So there's really very little in dispute. And there's really only a couple of outcomes when that's the issue, that the tenant hasn't paid the rent. The tenant can agree to move out of the property within a certain number of days. That can be the same day, perhaps, or they agree to move out within a couple of days, or the parties could agree, the landlord could agree that the tenant has 2 weeks to move out, but that's an agreement that the landlord and the tenant make. That's option number one of what can be agreed to between the parties. Option number two is that the parties agree to a payment plan that allows the tenant to remain in the property, but to pay the back rent, so the rent that is owed, and also pay the rent that is due in the future. Usually, how long? If you enter into a payment plan, and this is important too, there's no legal obligation to enter into a payment plan with a tenant. Many landlords do, because it's better to have someone in the property than have the lot or the apartment or the home, whatever it is, empty and search for another tenant. But if it's a problem tenant, like we've said Donnie is, you might not want to enter into a payment plan. But if you decide to, how long that payment plan is also depends on you. You could tell the tenant you have 30 days to pay what is owed, and you have to keep up with the rent that is owed in the future. You could make a payment plan for 60 days. You can make it 90 days. You could make it 6 months if you wanted to. That is something that the parties agree to. But I think the really important thing that I want you to remember is you don't have any obligation to do it. Sometimes tenants, I think that a landlord has to agree to a payment plan, but they don't. If, however, the parties have something in dispute, let's say that perhaps the tenant says, hey, I paid you, I made a payment towards my rent and you're not counting it. So I'm really not late on my rent that is owed. Or there's some other dispute about the amount that is owed. Or maybe the tenant claims that they're really not behind in rent. In that case, there's a factual dispute and the court will schedule a trial. A trial is never heard at the first hearing. Instead, the court will schedule the trial for within 7 days from that initial hearing. Most parties don't want to have a trial because, well, generally there isn't a reason to have a trial with non-payment of rent, but it also involves, the expense going back to court and just the added inconvenience of all of that. It doesn't happen very often. In the 10 years that I've been dealing with landlord-tenant stuff, I've had three trials. So, you know, most of the time it's going in and making a payment plan or the tenant agreeing to vacate. So one really important term that I want to talk about is down here in the bottom left-hand corner, and that's right of redemption. So the right of redemption, or the right to redeem, we also call it that, is a right that all tenants are entitled to when an eviction action has been filed against them for non-payment of rent. And what that means is that as long as the tenant remains in possession of the property, the tenant can pay the amount that is owed, and that would be the amount that's stated on the complaint, and remain in possession of the property. So can stay there, in other words. So let's say that at this hearing, the parties agree that the tenant will move out within 5 days. Within that 5 days, the tenant, the defendant, is able to gather together the full amount that is owed and that's stated on the complaint. The tenant pays that to the landlord, and the tenant can stay in the property. And all tenants have that right of redemption when the claim, again, is based on non-payment of rent. So when you're in housing court, as I said before, the issue in front of the judge is this really narrow issue of who's entitled to possession of the property. At the end of the hearing, the judge will issue an order that will state essentially what the judge is ordering, you know, that the parties have agreed that the tenant will vacate, that they've agreed to a payment plan, whatever it might be. And that order will also include an amount owed. And that will include back rent, filing fees, late fees, things like that. That amount stated on the order that the court issues in housing court is only for the right to redeem. That order doesn't mean you can then go with that order and collect anything from the tenant. To get an order from the court that says you can collect money from the defendant involves all of this over here on district court. So that's important to keep in mind. The order that you get in housing court is strictly limited to this issue of the right of possession of the property. And that amount listed on the complaint is only the amount that the tenant has to pay to redeem his or her right to stay in the property. So there's often confusion about that, of what that amount listed on the housing court order actually entitles you to. And as the landlord, it doesn't entitle you to anything beyond the amount that you have to be paid by the tenant to stay in the property. Okay. Let me see, let me just look through my notes here. Okay, we're gonna go we'll come back to this slide, but I wanna go back to this example of Donnie. So let's say with Donnie, you took him to court and for unpaid rent, right? Because we said he had not paid he owed you about $1,000 for late fees, for rent and stuff like that. So in our situation, the hearing with Donnie was scheduled on September 25th, yesterday. And you reached an agreement that he agreed to move out by October 1st. The amount to redeem would be probably about $1,400. That would include the $1,000 that we said Danny owed, plus about $400 for service fees and for filing fees, because you're entitled to collect service fees and filing fees from the defendant. So this would be his amount to redeem. So the options for the outcome are that he exercises his right to redeem. He pays you $1,400 before October 1st. and he can stay in the property. He could vacate by October 1st, or he fails to vacate. And sometimes tenants do that. They hold over afterwards. Okay. So if, and we're going to talk about later on, if he vacates by October 1st and leaves his house on your lot, what can you do? You know, what are your options as a landlord for when there is an abandoned house? And we'll also talk about if he vacates by October 1st, he probably hasn't paid you that $1,400 or any part of it. So again, then what are your options for recovering that money? So a couple of points. If with option 3, if Donnie does fail to vacate, what can you do? You can't just, you can't take the law into your own hand, essentially. So you do need to involve the court and also the sheriff to get rid of a tenant who has failed to vacate by the day that they agreed to. So what you have to do in this case where there's a tenant who has failed to vacate is you file an affidavit with the court, and the affidavit lays out the facts that we were in court on September 25th. We came to an agreement. The defendant, Donnie, agreed to vacate by October 1st, and he has not. You file that affidavit with the court, you get what is called a writ of I can't think of it, a right of recovery, a writ to the right of recovery, but it's the document that the sheriff has to serve on the defendant that evicts the defendant. So you have to, after you get it from the court, you then have to bring it to the sheriff, pay a fee, of course, to the sheriff, and then the sheriff will go serve it on the tenant, the defendant, to get them out of the property. So there's other steps. There's always other steps that you have to take, and other fees that you have to take as well in these situations, because you can't just, again, you can't just do things on your own. That's at least under Minnesota law is forbidden. Okay, so let's look at, even though I know this doesn't happen very often, perhaps never, in the parks where you're at, it is still an important point to pause upon and to mention that when you are in court for breach of a lease or violation of the Minnesota law, like we were saying that Donnie is playing his music loud at night, you've gotten all of these complaints. Probably in the lease or as a park rule that there's a quiet hours between 10 p.m. and 7 a.m. that you can't have loud music. So playing the loud music at all hours of the night would be in breach of a lease provision, and it's also in violation of Minnesota law. All tenants have a right to what we call quiet enjoyment. So if you're bringing a complaint for breach of a lease or Minnesota law, there's no right to redeem. So that right to redeem is only when it's for non-payment of rent. And very likely a trial will be held, because usually defendants don't agree with what the landlord is saying, and there's usually a dispute about whether the music was being played loudly or not. A trial is always held within 7 days of the first hearing, the initial hearing. And what happens is what you kind of imagine. You come to court with witnesses, with perhaps other type of evidence, with documents, and then the possible outcomes is the judge decides. So based on the evidence, based on the witnesses, based on what the judge heard, did the defendant violate the lease or violate Minnesota law, and does the tenant have to vacate? And the landlord therefore has the right to possession of the property, or did the plaintiff, the landlord, not meet its burden and not prove that there was a violation of the lease or Minnesota law, and the tenant retains the right to remain in possession of the property. As I said, I've had 3 trials in 10 years, so certainly doesn't happen very often. And because it leads to a trial, it's always the least preferable way of going to housing court. It's much easier to evict someone for non-payment of rent, simply because there aren't the same factual disputes. Other thing I want to note, we saw, let me just go back here. Here we go. Under housing court, we talked about eviction actions and unlawful detainers. And there's also this other claim that can be brought in housing court, and this is called rent escrow. So I want to pause a minute and talk about that. So rent escrow is the claim that a tenant brings in housing court. And this is a claim that a tenant brings when the tenant is claiming that the housing, or perhaps the park, it could also be for the park, is somehow unsuitable for living. So let's say that in a park, you know, the park was providing utilities, and let's say there wasn't hot water, or the park was unsanitary. The park didn't maintain, you know, sanitary living conditions. In an apartment, it might be that there's mold in the apartment, or there's no heat during the winter. Whatever it might be, the tenant is claiming that for some reason, their right of enjoyment and the right to live in a clean, sanitary, habitable place is being infringed upon. So the tenant goes to court and says that I'm entitled to pay less rent because of the conditions of the property. And this is if there's a tenant who is disputing that the park isn't maintained, this is the only avenue that they have to pay less rent or to not pay rent for what they are claiming it is these unsuitable or inhabitable conditions. A tenant cannot just pay rent in protest for what they claim, again, are these conditions, unsuitable conditions of the park or of the property. The tenant has to file the rent escrow action and also has to pay rent to the court. So rather than just withholding rent, they pay the rent to the court. And then once the tenant pays the rent, the action's been served, there's the hearing, then there probably would also be a trial with the court making a determination. Yes, the tenant is entitled to pay $300 a month less rent for last month and this month. And probably the court would also order the landlord to do something, you know, to fix the conditions and give a certain amount of time for those conditions, whatever it is that is wrong, to be fixed. So that's the only option that we'll be talking about here, where it's the tenant who's actually filing the claim. These again are more unusual and make up a much smaller percentage of what goes on in housing court, but still possible. Okay, the next slide is kind of just a summary of the right of redemption. And as I said, it's a right that all tenants have from when the court issues its order in case for non-payment of rent and until tenant vacates the premises. The amount to exercise the right and remain in the premises is listed on the order that the court issues at the hearing in housing court. And it doesn't entitle the landlord to that amount outside of the tenant exercising the right to redeem. An important point with the right of redemption and manufactured homes. So Minnesota statute section 327C.11. 327C is the chapter of Minnesota statutes that deal with manufactured homes. States that a resident in a manufactured home, of course, has the right to exercise the right to redeem for non-payment of rent. But if the landlord files an eviction action for non-payment of rent against a tenant more than twice in a 12-month period, and both of those times the tenant exercises the right to redeem, if there's a third time for filing another eviction action and the tenant exercising the right to redeem, after the third time, the resident can redeem only by also paying reasonable attorney's fees. So if we go back to our example of Donnie, so let's say here that Donnie agreed to move out by October 1st, and he paid the $1,400. So September 30th, he came to you and said, here's the $1,400. He's exercised his right to redeem. He stays in possession of property. Let's say October passes and he has not paid October rent. If you want to evict him, you have to file another complaint because he exercised his right to redeem for that complaint. So let's say near the end of October, you're back in court with Donnie again for just October rent and late fees. And you get another order from the court. The amount to redeem would be less, let's say that $700, just for ease of mathematics. At that second hearing, Donnie agrees to move out by November 1st. October 31st, Donnie comes with the amount that he owes and says, here you go. He's exercised his right to redeem for the second time, and he's entitled to that. So let's say November comes, he doesn't pay November. And he says, oh, I'll pay you, don't worry. I just got a new job, I'll pay, don't worry. So you believe him. December comes, he still hasn't paid, so you decide to evict him again. Same thing, you go to court, he agrees, he'll move out. Before that move out date, he gets the amount owed. That third time that he's exercised his right to redeem, he has to pay the reasonable attorney's fees to stay in possession of the property. However, and that could be great because these other times you can't recover attorney's fees. And this may seem great. Okay, I can get the attorney's fees. However, there's always a however. There's another Minnesota statute, and this is under section 504B. This is another chapter of Minnesota statutes that specifically deals with landlord-tenant stuff. And this limits attorney's fees in eviction actions for non-payment of rent to $5. So your recovery of attorney's fees is going to be pretty limited, $5. And I guarantee you would be paying your attorney more than $5 for appearing in court. And this is even if the lease, because most leases have a provision saying that the tenant has to pay the attorney's fees if the landlord goes to court. I've never seen a judge enforce that. And attorneys never even request it because you know you're not going to get it. The only money you can recover outside of what's owed through the lease is the filing fees for filing the complaint with court, which in Minnesota is now $300. And then the fees for serving the complaint on the defendant. And that can be usually around $100 or so. So essentially you can kiss your attorney's fees goodbye, which is part of the quandary that landlords are in, certainly when they're faced with going to court, because it's not cheap. Okay, let me just look at something here. So I'm about to start going back to our flow chart here and looking at the district court, all of this side of it here. So before I start on this new topic of district court, what that means, what are your options, I wonder if there's any questions, if anyone has any questions that they want to ask.
Karen, since there's a couple folks from Wisconsin on here, I'm just wondering, I mean, Wisconsin has its own set of statutes around, landlord tenant or manufactured home. And I'm wondering if, I'm sure there are some variables. I'm wondering if it's fair to say that the big picture process might be the same for Wisconsin, and then the difference, where might the differences lie?
I am sure that the big picture is probably the same, would be my gut guess. You know, the right of redemption is what we call a common law right, that this is probably in every state around the country, tenants have this right. It's not specific to any one statute, that it just is, it's just part of the common law. So I would imagine Wisconsin tenants have the same right. There's certainly, you know, eviction actions and rent escrow. This could be a difference, you know, attorney's fees, you know, perhaps Wisconsin law doesn't limit it to $5, for example, for the recovery of attorney's fees. They could have other limits perhaps on what landlords can recover, or not have any limits whatsoever. Another difference could be, you know, Minnesota law limits late fees to 8% of the monthly rent. That could be another statute that's different under Wisconsin law, or just the process. You know, Minnesota, the hearing has to be within 14 days of when the complaint is filed, and just the process for having a trial. Those days in that process could be different as well. But the big picture, I imagine, is pretty similar.
Okay, thank you.
And I guess this is a good point to also mention with the moratorium. So the moratorium that Governor Walz has issued, the last one, it was re-extended on September 11th. And it applies for eviction actions for residential properties, not commercial. So if anyone did happen to have any commercial leases, there isn't a moratorium for that. And last I heard that there's, I think it's under consideration of whether the moratorium will be extended again. It will be, if it's extended again, it will be in October, where Walz issues another executive order extending the emergency powers that includes the moratorium on evictions. So you can't take any type of action that would result in eviction. We're going to talk about in a little bit about recovering if a tenant has signed a contract for title agreement. Can you repossess, and can you bring essentially a breach of contract claim against that tenant? My reading of the executive order says no, because it's just an eviction action kind of disguised as a breach of contract. So it's any type of action that would essentially result in a tenant being evicted from the property. And as far as the state and the federal, housing law is a state issue. And so that's when I've been kind of, it's kind of strange for me also as an attorney. How can there be a federal moratorium when housing law is a state law matter? There aren't federal laws on housing, on the trials, on late fees. You know, this is state specific. So the moratorium that Walz issued is the one that we have to follow, and is the one that has placed the pause on the eviction actions. There are exceptions also to the moratorium. You know, when a tenant is endangering the health or the safety of others, but those are really limited, and attorneys have had a lot of trouble. Landlords have had a lot of trouble evicting even tenants who are endangering other residents as well because of the UD, or because of the moratorium on UDs, I should say.
Natividad, did you have a question?
Yes, I just, so it's state mandated, correct, by our governor, but so now on TV you're hearing, and this is what you're hearing from residents, well, you can't evict me because of the federal moratorium. So which one applies to us when it comes time? If, say, the governor decides no more extensions in October, but there's a federal moratorium, how does that apply to us? Can we go to court at that time if the governor says no more extensions?
No, the federal would still be in place.
So technically, it's still federal till December 31st.
You know, let me look at the federal moratorium, and I will get an answer for you. I don't want to give you the wrong answer, but I will see how they interact together, and I can get you an exact answer. If you can give me your email, maybe Tom has it.
Yeah.
Yeah, if you could send that to me, Karen, and then I think this is something we'll send to all our communities, all our reps, right? Because they have the same question. Everybody's hearing different things about, is it state, is it federal?
Confusing. It's very confusing.
Well, if you look at the laws of what the order is, so it's federal, state, city, county, or county and city. If federal says, yes, your moratorium goes to December 31st, a resident could argue the point with you as a landlord, but your governor in your state says, no, it's done. So then I could turn around and say, no, it's done, and we're going to evict you. Although we don't want to do that, we just need to know which one really applies so we stay on the same page across the board and we get to either December 31st or we get to now's the time to evict.
Right. Yeah, I'll get an answer too.
Yeah. With winter coming, it's going to be one of those things where, gosh, you just really, you don't want to be putting anybody out in the winter time, but it is what it is. I mean, that pays your bills. And so you get to that point where you have to make a decision. But if they argue it, who's right? The federal or the state?
Right. And I mean, I don't know if courts are even like, if I tried to file a complaint right now for a client, would the court even accept it? See, I haven't tried because there's no reason to, but I think the courts are accepting complaints.
Yeah.
So I guess you could file it and then see what happens. And, I've had a complaint that I filed in Pine County for a client in March, just before the moratorium the first one was issued. We filed these complaints, and the complaints have just been sitting there. The court contacted me a few weeks ago, said, hey, are you still going to need a hearing when the moratorium is lifted? And I said, yeah, we will, but they're just there. So, I guess that could be an option. I don't think it's the best option, but a landlord could say, well, I'm going to file them and just see what happens. And if they let them go through, they will. But I think it's better to actually have a clear understanding. But it's very confusing. I mean, all of these different orders and how do they play? Landlord tenant is state law, but how do they all kind of interact together and what are the courts doing? It's confusing for the courts too.
So my granddaughter's best friend just got evicted, their family, from their house.
In Minnesota?
Yeah. In fact, right up the road from us. Got evicted from their house and they're staying in a hotel for 4 or 5 days. I showed them the moratorium. They went back to their house for 3 days, packed it up, and then left. So I don't know where they're at right now. But the landlord did kick them out.
Right, because that's happened too. I mean, there's been articles in papers of landlords still doing things, thinking that tenants don't know
right
what their rights are. Sure. Okay. Any other questions before we move on with district court?
Can I ask the people in Wisconsin, do you guys have a booklet like this that comes from the Attorney General's office? It's on tenant rights. Are you able to access something like that like we do here in Minnesota?
Natividad, I don't think they can see what you're holding up because they're on their phone.
Oh, they're on their phone. Okay. Well,
I'll raise my hand though, Natividad.
What's that?
I said I'll raise my hand though.
Oh, okay.
We don't or haven't. I didn't know about it until you just mentioned it right now. We've not received anything from Attorney General here in Wisconsin.
Okay. I'm on the APAC board. I'll reach out to Dave Anderson, who's the ED from the director, and ask them if there's a way we can access a booklet for you guys. And if not, we'll figure out how to get one. And that comes directly from your Attorney General's office. So.
Okay, I could look online for it too.
Sure. That would be a great thing to have in hand because it does have that $5 fee for Minnesota in there, and it has a lot of tenant rights in there.
Yeah.
What's the name of the booklet?
It's called the Manufactured Home Parks Handbook, and It's offered up by the Minnesota Attorney General's office.
Okay.
Yeah, that's a good
I'll
reason.
see if we've got something. If you could check on that for me though too.
Yeah, I'll ask him today.
Okay, great. Yeah, because ours are different.
Yep.
In a lot of ways. But, so.
Okay, so let's go back to our flow chart then. And we'll talk about, so we've covered everything over here on the housing court side. So on the other side, we have district court. And this is this second option that landlords have for going to court against a tenant. And district court is, you know, regular court. It's where you go if you want to file for a divorce. Someone who's arrested, they end up in district court. Or if you sue someone, or if you get sued, you will end up in district court. As I said before, you know, in smaller counties, housing court is just held in district court. And housing court anyway is just a specialized court under the whole overall umbrella of district court. But for our purposes, like for Hennepin County, it's separate from the housing court. Oops, wait a minute, what happened? Okay, so for when you're in district court, you know, district court hears many different types of cases. And the issues in front of a court when you're in district court can be numerous. But when we're talking about for collections of how a landlord can collect what the tenant owes, the issue is whether the tenant breached the lease agreement and the amount that the landlord is owed. So it would be, you know, a narrow issue, and the claim would be breach of contract. And this tip is actually a good one to pause on, because this is kind of a theme throughout this when we're talking about collections. You know, if you do file a complaint, a claim against a tenant for breach of contract and claiming that whatever amount is owed, you will have the option probably at certain points of settling. And generally most people would recommend and urge that you settle. Even if that means taking less than what you claim you are owed. It's hard to get money out of defendants. It's very hard. It's hard to collect on judgments. And if you can get a settlement, it's always better, I think, to have less now than maybe something in the future that you might not get. So that's always, I think, a good option to keep in mind. So in our situation with Donnie, going back to him, if we wanted to recover the amount that the landlord that you're owed, we would go to district court and we would claim first $1,400, that was the amount that he didn't pay under the lease. So the unpaid rent, utilities, late fees, the service fees, the filing fees. And then other damages. Are there other damages that you've incurred because of Donnie and his tenancy in your park? It could be the time that the house or the lot, in our case, was vacant. You know, did it take you from when Donnie vacated, and let's say for purposes that he took his home with him, was the lot vacant for 3 months before you found someone else to you know, move in? That could be damages that you could recover. You know, a tenant is really liable if I sign a lease for 1 year and I'm evicted in month 9. I'm liable under the contract for those remaining 3 months, regardless. That was my contractual obligation to pay 12 months of rent. So if I get evicted at month 6, I, as the tenant, am liable for those last 6 months of the rent that is owed. And those can be damages that the landlord can recover. However, a landlord can't double dip. So let's say that Donnie signed a lease for a year, and at month 6, you evicted him, and he vacated and took his home with him. So really, he still owes you the remaining 6 months of the lease. But if you release that lot after 1 month, your damages are just the 1 month rent that you lost because of Donnie's eviction. So even though he really owes you the full year, the full 6 remaining months, because you found a tenant to move into the property, you've gotten the rent. You can't get it from both places. You can't say, oh, Donnie, you still owe me under the lease for the remaining 6 months, and also get the lot rent from the new tenants during that period as well. So that's what I mean, where you can't double dip as the landlord. But in district court, you can also recover if there was damage to the property. Let's say that when Donnie took his home, removed his home from the park, that he damaged the property, or when he was there, that he damaged landscaping or trees. He cut down a tree, he damaged shrubs, or he did damage something else, of utilities, whatever it might be. That damages are attributable to Donnie, so you could recover those. And you have to go to district court to do that. So the options in district court are considerations for this option, I should say, when you go to district court, is considering how much does the defendant owe you versus the cost consideration. How much will it cost you to try to recover the amount owed? And then also considering the recovery of judgment. So how likely is it that you will recover what you are owed? In other words, does the defendant have any assets that you might be able to collect from? If a defendant has failed to pay rent, has been evicted, they probably don't have a lot of money. So how are you going to recover on the judgment? Are there other assets? Is there a car that you could possess? Are there other things? So those are all, what assets does the defendant have to satisfy any judgment that you might get? You also need to think of pro se versus representation by an attorney. If you want to go pro se without an attorney, are you comfortable doing that, or do you want to pay an attorney to represent you? And that goes to how much is owed. If your defendant owes you $1,500, do you want to pay an attorney, $250 an hour to go represent you, or you might end up paying the attorney more than what you are owed. So that can be a consideration as well. The filing fees can vary, from county to county for conciliation court. In district court throughout the state, it's $300. So how much are you going to spend going after this money? You often get a default judgment, which means that the defendant doesn't even show up, so you get judgment in your favor. So what do you do with that? We'll talk about that. And another consideration for district court is, there's an appeal to the Court of Appeals, which is unlikely, but one never knows. So, those are all things you have to think about. I think the most important thing to consider is the amount owed. And then this, what's the recovery? Can you recover from the defendant anything that you're owed? That's always the big question. And what are the chances, or what's the likelihood of doing that? So all courts within the kind of the umbrella court of district court, there's 2 types. There's like regular court, and then there's conciliation court or small claims court. So conciliation court in Minnesota is for claims with a value of less than $15,000. So, most of the time when you have a tenant who owes you money, it's probably going to be less than $15,000. So you probably would be in conciliation. You can, if you're a corporation, you can appear without being represented by an attorney. Here, the filing fees vary from county to county, you know, $60 to $75. I think in Hennepin County, if I'm not mistaken, it's $70 or $75. It's a lot faster and easier than regular court. If you file in conciliation court in Hennepin County, you'll probably have a hearing within 3 to 4 weeks, or a trial, as opposed to regular court where you can have, it can take a year before you have a resolution or an outcome to your case. It's a lot easier than regular court as well. In conciliation court, you don't have to have an attorney. The filings that you have to make to begin a case, you know, to sue someone, to file a complaint, are very simple. It's a 1 or 2 page document that you file. Unlike in regular court where it's very complex, there's a lot of different documents, a lot of different motions, different procedures that have to be followed. And most people don't feel comfortable being in regular district court without an attorney. A conciliation court is very different. You go to the hearing, you have witnesses, you have evidence that you present, you tell the court, or you tell the judge what's happened, the other party tells the judge what happened, and you often have a decision, sometimes that same day, like at the hearing, the judge will reach a decision. If the judge takes it under advisement, as we say, you probably will have a decision within a week. So it's just a whole lot better than regular court. You do, if let's say you go to conciliation court and you get a judgment in your favor, the tenant, the defendant, can still appeal. And the appeal is to district court. So you could end up in district court anyway. I've seen this happen with a client that started in conciliation court and then ended up in district court, where then you have to find an attorney, where you're dealing with the expenses and the more complexities of district court. But for most cases that you have, I imagine you would be in conciliation court. But the tip, it's not like on Judge Judy, you know, there's never parties that are, you know, jumping over the benches or going crazy with the bailiff that's separating people. Courts don't allow that to happen, but it's similar in the sense that, you know, you're telling the judge what happened, and then the judge will reach a decision either then or shortly thereafter. Okay, so within the context of district court, we can talk about the contract for title agreement. So we'll go back to Donnie, and we'll put the situation that you've signed a contract for title agreement with Donnie, under which he makes payments towards the purchase of the home. And you at Cherry Grove Park, you're providing financing at a low interest rate for Donnie and for the purchase of his home. So for contract for title is, you know, essentially a purchase agreement for a manufactured home with financing provided by the park, who is the creditor. It's not a mortgage or contract for deed, which are terms that often are used to describe this, since a mortgage and a contract for deed is only for real property. So for, you know, actual land, or for you know, a building that's attached, so a home or some other building. And like a bank does with a regular home in a mortgage, you should, you know, you have or should have a security interest in the manufactured home as the creditor. So a security interest, the legal definition is a legal right that is granted by a debtor, who would be the resident, Donnie in our case, to you, the creditor, over the debtor's property, over the home. And this is the collateral. And this, the security interest allows you as the creditor to have recourse to that property if the tenant should default on, or if the debtor should default on the obligations of the agreement. The most common type of a security interest is, of course, a mortgage, right, where the bank holds that security interest in the home. If you buy a car through a dealership, they will probably retain a security interest in the car as well. So if you default on the purchase agreement and don't pay, the dealership can come and repossess the car, as a bank can repossess a home as well, and you have that same option. So this is always recommended. Never do a contract for title or purchase agreement without a security interest. You have to record, file the security interest with the Minnesota Secretary of State. You can do that online with a $20 fee. If you do not record the security interest, you cannot enforce it. So if Donnie were not to pay and you have the security interest, if that were not recorded with the Secretary of State, you can't do anything. The security interest in a manufactured home is treated differently than a security interest in like a car or some other property. I had a client once who bought a restaurant, and it was financed through the seller, the former owner, and the former owner retained a security interest in all of the equipment of the restaurant. The equipment, the tables, the refrigerator, the stove, everything. My client didn't pay. And one day he came in and found the restaurant was empty. The seller had come in and had repossessed all of the equipment because he had a security interest. And the security interest gave him that right to repossess without notice. A manufactured home is very different than restaurant equipment. So you simply can't go and repossess, and there's very specific steps under Minnesota law that you have to follow if you want to enforce a security interest that you've granted, that you've given in a manufactured home. And that's what we'll look at. So the Minnesota statute that deals with security interest and the rights of the debtor, the resident, and also the obligations of the creditor or the park, in our case, are in Chapter 327C.61 and the following sections that this SEQ period stands for and follows. So there's a whole bunch of statutes in this chapter that deal with the repossession of manufactured homes. And it's really strict. The statute even includes specific language that a creditor, the park, has to include in the notices that it sends, for example, to a tenant or to a debtor. So, specific language that if you don't follow that precisely, you can't repossess a home because you haven't followed what the law requires. So in sum, essentially, you have to provide notice of the intent to repossess. And that's one of the notices that the language is really specific. It has to be in capital letters. It has to include all of these rights that the resident, the debtor, has. In that notice, this first notice, you have to inform the debtor, the resident, of their right to cure the default, which means to pay the amount that is owed. And the debtor always has this right for 30 days after you've provided the notice that they've defaulted and that you intend to repossess. They have 30 days to cure the default, to pay what's owed. After 30 days from when you provide the notice, and it has to be certified mail, again, very specific, then you can go to court and ask for an order to seize the manufactured home and deliver it to the creditor. After that, there still is another 30 days where the debtor can still pay the amount owed and what is called reinstate the loan. So essentially they have 60 days from when you first provide the notice of intent to repossess to pay the amount owed and to reinstate the loan, to cure the default or reinstate the loan, essentially the same thing. and then you can't do anything. You know, that they've paid what's owed and the loan just continues. If they don't, however, and if you do get this order to seize and delivery from the court, you then have to file this with the Minnesota Secretary of State in order to actually seize the property. And I apologize, my dog is barking, I know. I think because there's something beeping outside, sorry about that. Within this whole option or whole process, there is also the possibility where the debtor, the resident, will voluntarily give up the home. And that can happen, and that would be what the statute calls voluntary repossession. That doesn't have to be filed with the Minnesota Secretary of State if that happens. But if you are going to go in and seize the property, that you do have to file with the Secretary of State to then act upon that. Let's see, hold on. Why are we going back to the end? Just a second here, let me look at my notes here. Let's see, I think we'll skip that. Yeah, okay. I was trying to say, like, wait, this seems out of order. Why do I have this here? So that's kind of that's everything that I have on the contract for title. I wanted to return to the collections. So when we were talking about with Donnie and going to district court for what was owed, for our purposes of our little example here, we're going to say that you've gotten a judgment against Donnie for $6,000. Right, that you went to Conciliation Court to recover the $1,400 from housing court, and then other damages, that he did damage the property, caused a lot of damage to the property, and the lot was vacant, or the house, if you were renting a house to him, was vacant for 3 months. So you get a judgment from Conciliation Court that Donnie owes you $6,000. What do? You got this nice piece of paper that says, again, Donnie owes you $6,000. It would probably be $6,075 or $70, because you can also recover the filing fee from conciliation as well. So if you're at Conciliation Court, the judge would issue you a judgment in your favor, and you get this nice piece of paper that says you are entitled to $6,070. And oftentimes the judgment, the money that you're entitled to, is worth the paper that it's written on. You're not going to, that's it. That's all you get, is this nice piece of paper. There are options, but it's really difficult to collect the amount that is owed on any judgment that you're given in court. And that's just the stark reality of it. Defendants don't always pay what they're owed in an eviction action or in any type of claim. They might figure they already have other judgments against them. Maybe they've defaulted on some other payments. So what's another judgment? You know, a lot of people look at it that way. Or maybe they want to pay, but they simply don't have any money to pay. So they have a judgment against them, even though they'd like to, you know, keep up and maintain their obligations. And because of this is also why I suggest settling and reaching a settlement and getting some of the money that is owed. It's better to have something, maybe less than you think you're entitled to, but it's better that than having nothing. And the important thing to keep in mind about the whole collection process, and this would be true in both Minnesota and also in Wisconsin, is that you're on your own. That sometimes getting the judgment is the easiest part, especially if there's a default judgment and the defendant doesn't even come to court. So all you do is tell the judge what happened, you have your complaint, and you get it, you walk out with judgment in your favor. The hard part is trying to collect upon that. So once you do get a judgment in your favor, there's certain steps that you have to take if you're going to enforce that judgment. And the first step is docketing the judgment. And this is also called transcribing the judgment. And you have to file what's called an affidavit of identification with the court in order to then enforce it. Just getting the judgment from the court is not enough. You can, let's say I had a client in Minnesota and I knew that they had property in Wisconsin that I wanted to try to collect or seize to collect on the judgment, recover on the judgment. Or conversely, if there's a Wisconsin court that issues a judgment against someone that has property here, you need to docket or transcribe that judgment in the other state. You know, all states, they respect and they enforce judgments that are issued by other states' courts, but you also do have to docket that foreign judgment, we call it. So when a judgment is issued by another state, it's still referred to as a foreign judgment. And the courts will respect that, you know, and will abide by them, but it still has to be docketed. And it has to be docketed in the same county where you got the judgment. And if you're in Hennepin County, you docket it in Hennepin County or whatever county you happen to be there. So after you do that, if you don't know the bank account or the bank account number and also the bank itself where your former resident or the defendant has a bank account, you don't know where the person works, because that's information that you can use to try to collect on wages, to collect, you know, money that they're earning. You can request what's called an order for disclosure from the court. So this is an order that the court issues that is sent to the debtor or the defendant that requires them to fill out information about their assets, about where they work, about their bank accounts. So you, as the creditor, as the plaintiff, can then start the process to either garnish the wages, to levy earnings, to seize assets, to take steps in order to recover some of the money that you're owed. And I'm going to show you, I have here it is. Let me make sure I'm showing you the right document. Yes. So this is an example of the Minnesota financial disclosure form. And you can see, you know, what are your total wages? Do you have income from any other source? Do you have a checking or savings account? Provide the information. And the defendant or the debtor is required to fill this out. As you can imagine, most defendants do not fill this out. I've had cases I have one judgment that I got for $15,000 where I've never collected anything. This was sent and it was never returned. Someone who's not going to pay on a judgment is not going to voluntarily release this information. This is part of the process. The court can issue a bench warrant if someone doesn't fill it out and doesn't come to court for a hearing to explain why they haven't and to provide this information. But probably, you know, in the whole hierarchy of important things that the sheriff has to do or the police have to do, this kind of falls down on the bottom of the list. They have more pressing things to do. So it might not happen. So that's, again, part of the problem with all of this, with trying to enforce. But it is something that you can do, and that's something you can request. The best thing is if you have this information beforehand, a bank account, where the person works, because then you can obtain a writ from the court that you then go serve on the bank, or the sheriff serves on the bank, that will allow you to levy on earnings or to garnish earnings from the defendant. So this is the next step in fact. So if you do have that information of where the defendant works or where their bank account is, at that point, you can request a writ of execution from the court, which you then give to the sheriff with a fee, of course, to serve on the bank or on the employer in order to then try to levy or garnish the earnings. And this is another fee that you have to pay. You know, it's about $70, but it can vary from county to county. So all of this, you know, gets added up in the calculation of you know, how likely is it that you'll get anything. That's part of the calculation, because if you get an order for execution of this writ, and if it's served on the bank, you have to pay a fee for that. And if the defendant doesn't have anything in their bank account at that point, you don't get anything. And if you want to try again, you have to pay another fee. So it's not a, you know, ongoing thing that just stays there. And as soon as there's money, as soon as there's money in the account, that you get your share of it. Oh, here, I just covered this, but anyway, this is the kind of goes over that once you bring the writ to the sheriff files the writ with the bank or the employer, and then it can be executed upon. And if there's, you know, money in the bank account, then you will get that. If there isn't money in the bank account, you don't get anything. And you can, you know, keep track of, if you are going through this process, there's a lot of fees, there's a lot of, you know, additional money that you have to pay, that you can try to recover this from the defendant. You can keep a receipts and file an affidavit of increased cost with the court. And then that judgment that you're owed would be increased to include all of the fees that you're incurring with trying to enforce the judgment, because the defendant didn't pay. Another option is getting what we call a judgment lien. I'm sure you're all familiar with liens. There's different type of liens that are out there. There are mechanic liens, like if someone doesn't pay a subcontractor or a contractor. There are also what are called judgment liens. And you can get a judgment lien, and it can attach to the debtor's personal property or real property if they happen to have a land or a home or something like that. And then you can seize that, and it can be sold through a share sale to satisfy the judgment that is owed. One thing to know before you begin all of this litigation is trying to find out what assets does the defendant have. Because if you find out that the defendant, or, you know, the resident, Donnie in our case, you know, has all of these assets, then you can try to seize them and use that to recover the amount that's owed. If they don't have any assets to their name, it's probably not worth it even to litigate, because what are your chances of recovering? There are agencies here in the cities, it's called Metro Legal, and they do what are called asset searches. And it's like $7,500 or something like that. And they will search all of the public records to see what cars someone owns, for example, if they have real estate, if they have other property in their name, a boat, whatever it might be that would be listed with the state. Someone, of course, would have more personal property than that, but this can be a good idea to see whether there's any assets that you could possibly seize to satisfy a judgment that you get.
Karen,
A lot of exemptions on what can be seized or what can be attached. You cannot get a judgment lien to a debtor's manufactured home, that is exempt property. So, and that makes sense. I mean, if someone's living in a manufactured home, if that's their house, you can't, a plaintiff can't get a judgment and then seize that person's home. Just as real property, a home is protected from judgment to like $325,000, also manufactured homes are exempt from attachment. Cars can be, to a certain amount, are exempt from attachment. Personal belongings are exempt from attachment as well. So there's a whole bunch of property that you simply cannot seize and attach in order to satisfy a judgment. But if there is, let's say there is some property that you can attach that's not exempt, at that point, that's when you go through a sheriff's sale, that you have to pay the sheriff, who then conducts a public sale, to sell the property, and any proceeds from that sale will then go to you to satisfy the amount that's owed. That can also be with an asset search. I mean, if someone has a 1999 Toyota Cressida, how much is that even worth? Who would buy it? Because a sheriff's sale, you get money only if someone buys from that sheriff's sale. So if it's not anything that would likely be sold, how good is it? What is it a really good idea to throw good money after potentially bad money? That's all part of the assessment that you need to do in all of this.
Karen, I just wanted to point out, I think Natividad has a few questions, and I know we're coming up on time. Would it be okay if she just interjects now, or do you want to get through the rest of your presentation?
I have a couple more slides.
Okay.
So I finish these, and I'll talk fast. I mean, I can do a little bit longer. I don't know about you all, to answer her question.
Yep. Oh, that would be fine. I just wanted to check in about that because we're approaching. So, okay.
So to kind of, here, we just talked about that. And we talked about that. Once the property is sold, the proceeds go towards satisfying your judgment. There are collections agencies and attorneys that help with this whole process, but this is all part of the calculation. Is it worth it? They always usually take 33% or even 40% of what they collect. So that's less money that you get. They work on a contingency basis, so you don't pay them as you go, but it's still, again, it's part of the calculation. So some studies show that 2008 studies showed that people do better settling than going to trial. Another study from 91, so it's a while ago, probably still valid, showed that only 43% of plaintiffs received full payment 3 years after judgment. And that same study showed that 35% had received nothing from the defendant. A judgment is valid for 10 years and can be renewed. So, you can think, oh, they don't have anything now, but they might have something in the future. So you can renew it. You just need to keep on it to find out whether whether they've, gotten money or bought some property that you could potentially seize. This is important to remember. You can't squeeze blood from a turnip. This is a beet, but I couldn't find a picture of a turnip. But, essentially, if someone doesn't have money, you're not going to get money from them. Should we finish up? I mean, the abandoned home was the last thing. There is another process for abandoned homes. Oh, because that's it. So if Donnie abandoned his home, there's a whole other process under the law to acquire title. If someone has abandoned their home, you don't have title, you have to work with an attorney who has to file an affidavit with the court. You have to make sure there's no other security interests, other liens out there, other creditors that have a superior right to the home. And if there are no security interests, no liens, your attorney files an affidavit in this whole process, and then you can obtain title to that home. And once you have it, once you have title, you can do whatever you want with it. Sell it, rehab it, donate it, live in it, or whatever you might want to do. So there is a process in the law for that as well. And in the affidavit, you would have to state the facts of, how you got the home, how do you know that it's abandoned? And the more facts you have, if you have documents about that, the better it would be for the court to actually conclude that it is abandoned. So that's it. I rushed through the last few parts of it.
I didn't get the end of it.
Yeah. So, Natividad, do you have questions? Do you
Sure. We're getting ready to use the abandonment law. Actually, we're working with our lawyer right now on a home so that we can get a title and move it out. It's a really bad house that's falling apart, like literally onto the ground. That's how old it is. And so he's applying that situation right now. So we're hoping that it pans out because we already have a community or a broker that's going to come move it out, rehab it completely, and then it'll come right back in.
Oh, wow.
We're doing that with a couple of homes right now. My question to you, not 100% sure if this plays out to anything. We have in our occupancy agreement that people sign, because we have an open lease basically for life, so to speak. We don't have a year to year. They need to live in their homes on a continuous basis. And we have 3 homes right now where the people just come here once in a great while. One of them is an owner who had bought it at a sheriff's sale and has never lived in it for 2 years. So with that, how does that play out in law, since they signed an agreement that says, whereas the member has a bona fide intention to reside in the community and continue such residence during their membership? So that's where we stand right now. 2 of them are living with some other family members and taking care of family. And the one gentleman, like I said, purchased the home 2 years ago and has never lived in it.
Well, that would be breach of lease, breach of contract.
So then what happens right now with the COVID and moratorium, what does that mean for us? What do we do? Winter's coming now. We have 3 empty houses, literally, and it's just like,
right,
they own them and they're not living in them. And one last year had a water break in the winter, but of course was not there. So oh, it's her dog. Cute.
Sorry about that, barking dogs.
That's okay. Just
I mean,
how that works.
The question would be is, is looking carefully at the language of the executive order, for the moratorium, and seeing whether that breach of the agreement is an exception for evicting someone. I don't think so, because my understanding is it's the only reason you can evict with a moratorium in place is where there's that endangerment for other residents, and not living in it full time, even though that's a breach of the lease agreement, certainly doesn't endanger someone. So it probably wouldn't fall under that exception. You'll have to wait until the moratorium is lifted.
Okay. Winter's coming. That sucks.
I know.
This whole thing makes it really difficult. We have, we have the whole thing about not being able to evict somebody due to late rent that continues to grow. Money's run out in the state for some to collect money to help with rent. Some have applied it. We've gotten the checks just recently, so that's a big plus. Others will not be able to get it due to legalization. So it's just as a landlord, this whole thing has been really difficult as you watch things grow in trying to figure out the federal versus state moratorium. So that really is important for us to know and understand at some point which applies. And at what point do we say, okay, the governor says, but the federal says, so we need help on clarification. That would be awesome. And then applying park community rules, we're not even able to do that at this point.
And what about the inside of the home?
So we can't do anything about that.
About the inside of the home or the lawns?
No. We can't apply anything right now. Our hands are so tied. It's so frustrating right now.
Yes. No, that's exactly the case. Yeah. Again, from what I've read and understood, that Waltz is considering lifting the moratorium. Whether that will actually be the case, I don't know, but that's what I read after he extended it back on the 11th, on September 11th. We'll see.
Yeah, I have a feeling that's not going to happen because winter's around the corner now, and you don't want to be putting people on the street during winter time. But still, at some point, wow, it's frustrating. My shoulders are like this big right now, literally. So, and then I already asked Emily about getting a letter that we can resend out to people to, I can't ever say that word, reiterate, too much brain surgery, to keep letting people know that they still have to pay their rent. it still applies regardless, whether there's a moratorium or there's not, you still need to pay your rent. And I think people right now in the back of their minds, just a handful of them are like, well, I don't really have to pay. So that's climbing. And if we can continue to constantly resend that letter out, that would be awesome, on our letterhead that says this is how it works and this is what you have to do. Doesn't matter if it's $25 or $450. Pay something, pay your rent.
Karen, I had one community actually get a letter drafted by their attorney to send out to residents that were under non-payment. Would you recommend having cooperatives go to an attorney to get that letter drafted just to ensure that they're in compliance with current guidelines?
Well, there's no obligation that a landlord, provide that notice, but it certainly can't hurt. Some people see a letter from an attorney and take it more seriously. They're like, holy cow, it's a letter from the attorney. Other people are like, yeah, whatever. But it's one of those things that I don't think it hurts at all, especially just to remind people, because there is a lot of confusion over what the orders say, what the moratorium means, do I not have to pay rent? So reminding people of that, and reminding them if they don't pay, that they're still going to owe it, and they either face eviction or that you can collect on that and get a judgment. So reminding people of that too I don't think it's ever a bad thing to do.
Emily, if that's possible to have the language that they use, to also present that to our lawyer, and so we're on the same page, or however that can work.
I'll have Five Lakes, I'll confirm with them that that's okay that we share that letter and just make sure. But yeah,
okay.
I'll get on that. Yeah.
And we're going to include our community rules for the violations that we're seeing that are extreme right now. So that way, that's part of the deal as being evicted. So.
Great. Are there other questions that we have for Karen? Okay. Karen, your presentation was amazing. I learned a ton. It was so comprehensive, and I just really appreciate you going through each detail and sort of laying that out. It was really helpful.
Great. I'm glad to hear that. Do you want, I can send the presentation to you if you want to?
Yeah.
That would be great. Yeah.
Sure.
If you send it to me or Tom, we can forward it out to everyone.
Sure. And I have some other documents that I found that I kind of referenced here that I'll also attach. They're all just PDFs. Most are things like from the state, state documents and things like that, that I can include. And in addition, some information about the moratoriums and federal and state and all of that stuff.
Great. Cool.
Thank you so much, Karen, for all of your information. It really helps when you're talking to a lawyer versus just friends and other board members. You want to have correct answer by people who are stating the statute. That helps us a lot to attach statutes to everything we're doing, because then you're not considered that you're just making it up. I'm not making it up.
Yes, having the statute is always a good idea. Yes, that you're backed up by something. Yes.
Oh, 100%. Being on the APAC board too gives me way too much knowledge ahead of time, including the $5 attorney thing that I've been stressing for the last 2 years, and to actually see it and hear it from an attorney makes that clear to everyone.
It does. Yeah. And that needs to be updated. Something to contact your legislator about.
Oh yeah. We need to get that changed, and we'll put it on the APAC docket.
Well, thank you, everybody.
Thanks so much for the fabulous however many days it's been. How many? 7?
7 days, yeah. It's our last common ground session, so it was wonderful to see your faces.
It's hard to believe we do this in one day.
I know. I'm glad it seemed like it worked out okay, like spreading it out over a whole week. Because there's
now we're going to be bored. You better come up with something else.
Well, Peggy's going to coordinate those monthly calls, so don't worry.
Okay, that's awesome. Well, great to see everybody, even from home or the office. Have a great rest of the weekend.
Okay.
Bye-bye.
Bye.